Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everyone in between. My name is Dan Balkaran, as you see on the screen. I'm an employment lawyer at Samfiru, Tumarkin, LLP, which, as always, is Canada's leading employee-side employment law firm. A couple points of housekeeping. If you need to, I'll be your employment lawyer for the next 30 minutes or so. We usually go a little bit long. I'll answer all your questions that you might have, or I'll certainly endeavor to do so. Bit of housekeeping. If you need to get a hold of us, you can always do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, send in your questions. We don't have very many so far. But please send them in. Usually there's a flood of them at the end, and I certainly want to get to everybody that I can. Okay, question from Sir. Sir is back. He was here 2 weeks ago. When is an ROE supposed to be issued by your employer? An ROE, that's a great question, and I never remember the answer to this question. It's supposed to be issued by your employer for a change in status of your employment, an interruption in your employment service. So if you go on a medical leave or a leave of absence, or you're laid off, or you're terminated, the employer has to issue a record of employment and submit that to Service Canada. It doesn't actually have to provide it to you, though. They're required to provide it to Service Canada, and then there are times when the employer won't, for whatever reason, there might be animosity between the two, issue, or it just doesn't want to, won't issue the ROE to the employee. But you can always go to Service Canada, create an account, log in, and download your record of employment if it's there. Now, what I can't remember is the amount of time after the change of employment status. So, termination occurs. I can't remember if it's 48 hours or 8 days or what have you, but it's fairly close after your termination that they're supposed to issue one. If you Google it, I'm sure the answer will be on, I believe it's canada.ca, relatively quickly. You'll be able to find the answer out to that question. But yes, upon termination, they've got to issue you your ROE fairly quickly. Okay. And sorry, that's if you're applying for EI. For EI, it's necessary to have the ROE be issued. And then depending on the code that is used, Service Canada will either just issue the ROE, deny it, the EI, deny it, or follow up with the employer to find out more information. So, for example, if they listed your code as dismissal, then they may either just deny your EI or follow up with the employer to find out exactly what happened, because quite often a dismissal is actually incorrectly listed and is not something that precludes you from getting EI. So, and you get EI if you've been dismissed without cause or terminated without cause, but you don't get it if you quit or you were validly terminated for just cause. Okay. Jeffrey asks, can a business owner compete with employees for closing a deal? He receives 60% of all sales, but takes 100% when he closes one of our sales. We don't have any formal contracts. So you work in sales, you're commission-based. Commission changes based on who closes the deal, and the owner is effectively stealing your commissions. Well, the owner can do whatever the owner wants. The question is, have your legal rights been violated by doing so, and do you want to do anything about it? So, for example, if you're making $250,000 and the owner took, you're making $250,000, the open market will pay you $100,000, and the owner took $20,000 of your commissions. Are you going to do anything about it legally? Probably not, because you want to maintain that job. But if the owner is stealing half of your compensation, do you want to do something about it? Maybe. So, I mean, it depends on the context, right? So, could this be a constructive dismissal of your employment? Maybe. If you're making X amount sort of over time, and then the owner jumping in drops your compensation by 20%, 15%, something like that or more. Yeah, it could be. I just, yes, I think it's possible, but I think it's really very much, it turns on the facts of the situation and your compensation across time. And you definitely want to speak to an employment lawyer. I'll say generally, if what we're talking about here, Jeffrey, is a little bit of the total pie of your compensation, it's not going to be anything. But if your compensation is substantially altered by this, and it's altered by this it has to be on a permanent basis. So it can't be, and I know it's impossible to say that the owner will continue to do this, but if it's a one-off sale, right, then I think that would be tough from a constructive dismissal perspective. If you don't have any you could also have a breach of contract claim here. So let's just say this is $1 million deal and you're going to get $300,000 in commissions or something, right? And this is a big deal for you to lose out on. If you don't have any contracts, but you've been there for 3 years and deals always close the same way, could this be a breach of contract by the owner to rob you of your commissions? Yeah, I think it possibly could be, but you'd have to have a consistent track record, because there's no contract, a consistent track record across time of deals closing the same way, and then this being an aberration, and this being an aberration clearly because there was a lot of money at stake and the owner wanted that money for himself. And I'll just say this kind of thing, I've never heard of facts quite like these, but businesses not wanting to pay commission to employees to sales employees to which they owe substantial amounts of commission is as old as business itself, or at least sales. It happens all the time. Businesses just don't want to pay out. If you're an employee who is owed a substantial amount of money in commission, if you're owed $250,000 in commission and the employer hasn't paid it, chances are they're not going to, and they're gonna try to whittle that down through the law, force you to sue them. It's a tough situation. You want to make sure to the best that you can. Like, I know that employees or employers induce sales employees, high value sales employees, to work for them with promises of these high commission rates. But and that, and I'm not certainly giving anyone employment advice about which jobs they should take, but it is not infrequent that employers actually don't pay out the commission to which they owe. And so to the extent you have the negotiating leverage, having contracts that, generally it's good not to have a contract, but having a system by which you can ensure that you get paid those commissions certainly is beneficial. Jeffrey, I'll just say to the end there, we don't have any formal contracts. I don't really know what that means. Like, you don't have contracts at all, any written contracts that you signed? Okay, so if that's the case, generally that benefits you. So an employment contract is there generally for the benefit of the employer. It's there to limit the amount of liability the employer has to you upon termination, primarily. There's other components to it, but that's its primary purpose. And if you don't have a contract, you automatically get the common law upon termination. And on top of that, you are entitled to anything that you would get. So if you have a best day severance of 24 months coming to you, whatever you would have earned in projected commissions across those 24 months, you're entitled to. So it's good that you don't have a contract. But whether or not this is a breach of contract or a constructive dismissal, it's entirely dependent on the facts. I don't have enough. You should 100% speak to an employment lawyer as soon as possible. Again, if you want to talk to us, you can do that at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Steve asks, when can an employer enforce a non-compete in a contract? Okay, this is a good question. It's a very good question. Okay, so restrictive covenants generally come in two types: non-compete clauses and non-solicit clauses. Now, just to broadly simplify, although it's not quite that simple, non-compete clauses are, well, I'll just explain what they are in brief. So non-compete clauses say that you, the employee, cannot engage in business that's competitive against the employer in whatever segment that you work in, or maybe the whole employer, for a specific amount of time in a specific geographical area. Okay. Non-solicit say that you can't, non-solicitation agreements say that you cannot steal or poach after you are no longer an employer employees. So you can't, now you work for ABC company, and you can't say to the employees of your old company, hey, come work for me or come work with me. So you can't steal employees, you can't steal clients. So you can't poach your old clients for a period of time. Non-compete clauses are presumptively, this is not 100% accurate, but I'm just going to say it anyway. They're presumptively inadmissible. That's not 100% true, but generally speaking, it's true. Unenforceable. I shouldn't say inadmissible. They're unenforceable, but non-solicits are enforceable. And so, to really explain what I mean by that, if you make widgets, and you've made widgets for 20 years, and that's all you know how to do is make widgets, and you have a non-compete clause, and you've got kids and a mortgage and serious responsibilities, and then your company fires you, and all you know how to do is make widgets, what your non-compete clause is doing, and let's just say it's a 2-year non-compete clause, it's preventing you from paying your mortgage and feeding your family for 2 years. And that is contrary to society's best interest. And so it's very unlikely that a court is going to enforce a non-compete clause, because you need to be able to earn money and feed your family and pay your mortgage and all that other stuff. Now, generally speaking, the way the courts will do this, find them unenforceable, is if the geographical limitations are too broad. So, all of BC, or all of Ontario is probably too broad. Certainly all of Canada or North America, too broad. If the geographic or the temporal limitation is too broad, so 5 years, 2 years is probably going to be too long. 2 years might be okay, but generally shorter is better. And if it's too all-encompassing in other ways, it needs to be tailored, limited, and specific. Now, generally speaking, you're an average employee, a rank and file employee making widgets, it's not going to apply to you. If you're a C-suite senior executive employee, it might, because you have possession of valuable insider information, and you've been theoretically compensated appropriately to offset that risk. So generally speaking, below VP rank, probably not going to apply to you. And generally speaking, non-competes are likely to be unenforceable. However, having said all that, Steve, if you worked for ABC company making widgets, and now you're going to work for DEF company making widgets, it's still a loss for everybody if ABC company, threatens to sue or actually sues you, and DEF company threatens to sue or actually does sue you and ABC company. I'm sure your new employer wouldn't be happy about that. So you want to the extent you can, try to limit your exposure with respect to that. And there are certain things you could probably do. But generally, if you're a rank and file employee and you go work for a competitive company and you have a non-compete and the non-compete is enforceable, what's the harm to the business? The business still has to prove that there was harm by you working for that other company, and it's very hard and expensive for it to do that. And generally speaking, an assurance that you will not poach clients and customers for a certain period of time will allay their concerns and forestall some sort of ongoing litigation. Now, obviously, I can't guarantee that, but that's generally speaking the case. Non-solicitation agreements. You can't steal employees. You can't steal, steal employees. You can't poach customers. It gets a little fuzzy on potential customers, which a lot of non-solicitation agreements have. But same idea, the broader the clause, the less likely it is to be enforceable. But broadly speaking, they are enforceable. Don't try it. If you have a non-solicitation clause for the period of time it operates, don't poach if you're former employees. Don't poach former clients, because the remedies can be serious. They can be disgorgement of profits. So take those ones very seriously. You got a lot more breathing room with non-compete clauses. Steve, if you have any concerns about a specific situation, like if you are actually going to work at a new employer and it is competitive, you might want to talk to an employment lawyer. If you want to talk to us, again, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Grace asks, my boss is selling one of his businesses and is transferring me to a new location. I've worked here for 27 years. What will happen to my severance entitlements? There's not enough information in what you're providing me, Grace, in your question. So it sounds to me, I'm just going to infer, I'm going to make some assumptions. So your boss is selling one of the businesses and you work for that business and is transferring you to a new location in the new business. So this is very tricky. So if it is a share purchase, you are still an employee of the outgoing business and you can continue to work for them unless they terminate you. If you're being terminated in that process, well, you'd have an action against probably the new owner, although I'd want to take a look at that. If it is an asset sale, okay, then you're terminated in that process automatically. But if you continue working for the new business and they don't say that this is your first day and we don't recognize your previous length of service, at least in BC, I don't know about the nuances in other provinces, then your length of service continues for the purposes of severance assessment. Where it gets tricky for you is if you've been terminated in this process, which seems sort of like what's happened, but again, I'm making some assumptions here. If the job they've offered you at the new location is substantially similar in pay, duties, and rank, well, if you lose a job, if you're terminated from a position, you have a legal obligation. Your right to severance is not unfettered. You have to make reasonable efforts to look for replacement employment. And if your boss is saying, here, I have this job that's the same, it's just over here and it's within a reasonable distance, it's within an hour's drive or something, I think your claim, you don't have a claim. I think your severance claim is zero and you likely lose all of your severance entitlements. It's unfortunate. It does happen that way from time to time. It's very rare, but Grace, you really this is a very, very complicated situation. You 100% need to talk to an employment lawyer. You need to assess what your entitlements are, where your risks are, and if there's a chance to go. 27 years is a long time. You might have a substantial severance claim. It could be now is the time to go after it. So you should talk to an employment lawyer immediately. If you need to talk to us, employmentlawyer.ca, help@employmentlawyer.ca. 1-855-821-5900. And Grace, I've done a lot of work in that area. If you're in BC, I don't know if we have my contact. I can't remember what it's called. The little image. Yeah, there it is. If you're in BC, I've done a lot of work in that area. You may want to reach out to me. But otherwise, Grace, you need to talk to an employment lawyer immediately. Okay. Arthur asks, I've requested to move to a full-time office position after having a heart attack. I see, so you're out in the field, I guess. I do 50% office work, 50% construction. Employers being difficult about this. Can they fire me? Oh, it's a really tough question. So first of all, I'm sorry to hear about your heart attack. I wish you the best of health with that, a full recovery, and all of that. That's obviously very, very serious. I do 50% office work and 50% construction work. Employers being difficult. Yeah, so there's a doctrine called frustration, a legal doctrine called frustration, where if through no fault of either party, you're no longer able to perform the fundamental requirements of the job on a permanent basis, then your employment is extinguished, and including all the obligations of the employer to you, including severance, also extinguished. So it's a terrible thing. Now, they have an obligation to accommodate you to the point of undue hardship. But if you're doing half construction work in the field, now saying, well, I just want to do a desk job, is that undue hardship? Yeah, it might be. It depends on how integral to your job the field work was. Okay? These are tough things. I think, Arthur, if you can swing it, so if they just refuse to accommodate you, you'd have a human rights complaint. If you're in BC, I don't know about other jurisdictions, but the backlog in BC is 4 years, they say, to get to an actual adjudication. I bet you it's longer. You'd have a human rights complaint if they refuse to accommodate you. What do you do at that point? Do you continue to work in the field, but do you risk another heart attack? Do you quit and claim you probably quit and claim constructive, like, depending on how serious this health thing is, right? Like, if this is more than just I need to probably work from home. If it's I absolutely need to work from home because I can't have another heart attack happen, and it's a possibility if I continue to work in the field, then you'd probably quit and claim constructive dismissal. But it's tough. It's tough because you're not able to do a fundamental tenet of your job, and they don't have an obligation to accommodate something or a change that is effectively frustration of contracts. So, I mean, again, Arthur, I know I sound like a broken record today, but you need to talk to an employment lawyer. You need to talk to the employment lawyer before you do anything, because this is extremely tough. And, the lawyer is going to need to know about exactly the details of what your job is, what your capabilities are, why you're required, you need to work from home. I think the best situation for you, though, is an amicable solution. And so an amicable resolution, you give doctor's notes saying, I need to work from home, and you keep pushing on it through that means. You paper it, and you see if they can figure out some sort of hybrid with you, especially if you've been there a long time. Maybe they can do that. So that's probably the best result for you, but it's a tough one. It's a tough situation, because 50% construction, it's hard to argue that the field work isn't fundamental to your position. So, but yes, Arthur, talk to an employment lawyer right away. If you need to talk, get a hold of us. employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Jay asks, can an employer terminate you for asking for a copy of your employment contract? Can they refuse to give you a copy? Okay, so this is actually a good point in time to I think people forget what the employment relationship is. Your employer can do anything it wants, okay? Effectively, limited by your legal rights and your ability to enforce your legal rights. But you have to remember that when you attempt to enforce your legal rights, the moment you pick up the legal sword and shield and come at your employer is going to not be so happy with you, and it's going to sour the relationship. At some point, you're probably going to be out of there. Okay. So when you ask for a copy of your employment contract, generally, what employers who are savvy here is, this guy's gearing up to take a run at a big amount of severance, right? And the differences can be stark. The statutory minimum for a long service guy could be 8 weeks versus 24 months if you get into the common law, which, you're making $100,000 a year. That's $200,000. Like, that's a lot of money for any business to absorb. So, asking for a copy of an employment contract does raise red flags for the business, but or at least an antenna, like, hey, we need to keep an eye on this guy because, who knows what's going on here. But, there are lots of times where, you look at the person I was just talking to about the possible constructive dismissal with his after his heart attack. Like, he's going to want to know what his rights are upon termination, because if they're 8 weeks, then, or some other circumscribed limit, he's probably, it'll affect his decision about what he does. And so, you do have to ask from time to time, but yeah, it will raise red flags for your employer if you ask, which is why always keep every document you sign, every employment contract, every addendum, every promotion, just keep them all, scan them, put them in a file somewhere, make sure you have them later. It will make your life easier down the road. Some of you will work at the same employer until you retire. That is not going to be the case for the majority of you. The majority of you will at some point move on, whether voluntarily or not, and you want to have easily accessible all your contractual paperwork. So great question for that. Can they refuse to give you a copy? Yeah, they can do whatever they want. And they don't have to. An employer does not have to give you any documents until you sue them. But it doesn't want to be sued if it can avoid it, because that gets expensive. So almost all the time, it's going to give you the documents ahead of time. But sometimes they don't. Some employers are more difficult than others when negotiating with their employees. Some of them are generous, and some of them are, take scorched earth positions and don't want to give their employees a dime. So it just depends on each employer and the we'll just say the individual personality of that employer. But yes, always keep all of your contractual documents. Okay, we're almost done. I've been sort of methodically going through these, so I'll try to answer these 3 last questions quickly. All right, this is from Hello. Is it considered reduced hours when being forced to use sick hours due to no remote from home work available? Medical assertion is only around movement requirements, not the number of hours. I don't understand your question at all. I'll just say, if you have to work from home for some other reason, you're not unwell, and if you're claiming to be sick, that could be a problem down the road. It could be that you are being dishonest to your employer, which could terminate you for just cause, which means they can pay you 0. Okay, so I'd be very careful about claiming to be sick when you're not. Now, do people do it? And if there are one-offs, yeah, there are, and employers look the other way. I have a lifelong friend who we used to work together in technology many years ago, and his boss was also friends with me, and it was a running joke that every year for the World Junior hockey finals, he would be sick, and he knew it. He was a great employee, so his boss knew it and just looked the other way. But you don't want to give your employer ammo to fire you and not pay you severance. So be careful, very careful about claiming to be sick when you're not. But otherwise, I don't understand your question. If you can clarify, the recommendation is supported by my family doctor. Okay, sure. But I don't know what the recommendation is. To work from home? If your doctor says you have to work from home and your employer says no, I don't think the doctor can dictate to the employer that you have to work from home. I think that that's a bridge too far. I could be wrong, but then we'd see an epidemic of medical notes saying, well, we've got to work from home. Okay, that was what you were asking. Yeah, you can try it. I just don't think it's necessarily legally enforceable. If your employer requires you to be in the office and it wasn't part of your contractual arrangements that you work from home, I don't think, could, from a human rights perspective, you have a claim on the discrimination on the basis of disability? Maybe, but I think that's I really have a hard time seeing any sort of legal body saying that a doctor can force your employer to have you work from home. So I think the best, you provided the medical note, see if you can come up with an amicable arrangement with your employer. Really quickly, Sammy asks, can an employer restrict you to leaving the premises during your lunch break? New managers is saying we're not allowed to leave when we're on a break. I don't think so. What's your ability to enforce? If you say no, if you say no, and are you committing or if you just do it, are you committing insubordination? Probably not, but then you've been fired anyway. If your doctor says you need to get a walk every lunch for your health, you might want to provide a medical note saying that. But no, I don't think so. But again, it comes down to what happens if you just refuse to follow that. Is your manager going to fire you? And are you okay with that? It's a very weird thing. I've never heard of anything like that. I would just say generally, if your employer is saying you can't leave the premises, it's kind of a restrictive relationship, and you may want to assess whether that's the right fit for you. Again, I'm not providing you specific job advice. I just know that's quite the thing to say. Last person, can employer terminate employee who's on leave due to ethical issues such as theft? Well, that's not an ethical issue. That's you committed if you committed theft, of course they can terminate you for theft and most likely pay you zero, because stealing from your employer, generally speaking, is going to be is going to result in or is an enforceable termination for just cause. So if you did in fact steal from your employee, I don't know if it's theft in a criminal sense from somewhere else, but if you stole from your employer, yes, of course they can terminate you, and you probably have no claim to severance, and in that situation, you're probably going to want to just move on. So, I mean, again, you can talk to an employment lawyer, and just generally for everyone I did talk to, I mentioned that a lot of you had to talk to an employment lawyer. You also might want to, depending on the nature of what was being alleged. It's hard in one sentence to understand what the theft was, but certainly you can reach us at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Okay, lots of questions, lots of good questions. The employee just went for sudden leave to escape from the investigation and get a doctor's. Yeah, I don't know. Yes, they can terminate you for theft. That's for sure. But if there's a medical leave component in there, it might be more complicated. Join us next week. I don't know if that already appeared on the screen. There it is. Chris Justice, Monday, February 26th, answering 1:30 Eastern time, answering all your questions in employment law. And I will or should be back. I haven't looked at my schedule yet, but I should be back in 2 weeks, same time slot, 10:30 a.m. Pacific time, answering all your questions in employment law. Excuse me. Thank you for joining us. Thank you for the great questions. Have a wonderful and safe weekend, everybody.